yesterday I discussed the Supreme Court's historic, courageous, and correct decision in Dobbs. But that landmark case was only part of the most consequential Supreme Court term in almost 70 years, since Brown overturned Plessy in 1954. For example, in the space of 1 week, the court took 2 huge leaps forward for religious liberty. 2 big steps to restore and strengthen America's First Amendment right to pray and worship how they choose and raise their kids accordingly. Time and again, we've seen opponents of religious diversity argue that government ought to discriminate against faith-based undertakings and organizations. These efforts have spanned from the anti-Catholic Blaine amendments of the 1800s to today's efforts by the secular left to chase religion out of the public square. We've had Democrat politicians trying to force nuns to pay for birth control against their will. 49 of 50 Democrats just voted for a radical bill that would have forced faith-based hospitals, listen to this, forced faith-based hospitals to perform abortions against their principles. Last year, Washington Democrats tried to pass a sweeping toddler takeover that was written to squeeze out faith-based child care providers and secularize early childhood in this country. For goodness sake, 5 years ago, a Lutheran preschool in Missouri had to argue all the way to the Supreme Court that it deserved equal access to widely available funding for updating an outdoor playground. Textbook anti-religious discrimination. Fortunately, they won easily, 7-2. This is indeed a new Supreme Court. Last month, the court took another landmark step. The case with Carson versus Mackin arose because the state of Maine had established a school voucher program that tried to uniquely discriminate against faith-based schools. In effect, the government was using taxpayer money to nudge families away from faith-based education and toward secular private schools instead. The court rightly struck down that law. Chief Justice Roberts explained that Maine could not exclude accredited and otherwise eligible schools purely because they are religious. That's not government choice to make. It's up to the parents. A few days later, the court issued another important and common sense ruling. Joseph Kennedy, a high school football coach from Washington State, was fired, listen to this, simply because he quickly and quietly offered a simple prayer on the field after the games. He got fired for that. The man was fired by government bureaucrats for praying. In our country, the court ruled for Coach Kennedy under both the free speech and free exercise clause of the First Amendment, thank goodness. In the process, Justice Gorsuch and his colleagues cleared away many, many years of phony, made-up legal tests that made our laws needlessly hostile to religion and turned back to what the Constitution actually says. So the court's term was an exciting one for Americans of faith who simply want to be allowed to live out their faith and raise their kids. But this was a win for the entire country. Americans of any faith and no faith at all can celebrate that we have a brilliant majority of originalist, textualist judges who will defend all of our constitutionality, guaranteed freedoms, and apply what the Bill of Rights actually says. In a better world, Mr. President, in a better world, neither of these common sense rulings would have been close calls or breaking news. But since they were very good news indeed.